The first case on this morning's docket, case number 115110, State of Kansas v. Brian A. Murren.
Good morning. I'm Rick Kittle. I represent Mr. Murren, and I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Briefly, what this case is about. Mr. Murren was charged with 4 offenses: possession of marijuana, possession of drug paraphernalia, criminal trespass, and interference with law enforcement. At his trial, there was a considerable amount of evidence about intoxication, so much so that the court did give voluntary intoxication instructions for the crimes of possession of paraphernalia and marijuana, but did not give instructions for the other 2 crimes. After Mr. Murren was convicted, he appealed. One of the issues he raised is that clear error was committed when the court failed to give an instruction on voluntary intoxication for the crimes of criminal trespass and interference. After the Court of Appeals affirmed his conviction, he filed a petition for review, and this court granted review on the sole issue of whether it was error for the court to fail to give voluntary intoxication instructions on criminal trespass and interference with law enforcement. Unless the court has other questions about the facts, I'd move to the issue here. The statute at issue reads, when a particular intent or other state of mind is necessary element to constitute a particular crime, the fact of intoxication may be taken into consideration in determining such intent or state of mind. Now, my understanding of how that statute has been historically viewed is that there are basically 2 instances when voluntary intoxication may be given as an instruction for a particular crime, and that's when the particular crime has a specific intent that must be proved as an element of the crime, such as for theft, intent to permanently deprive, or for some sex offenses, intent to arouse sexual desires, elements such as that. The other instance is when, and this was in the Ludlow case, this court's case State versus Ludlow, which basically said that the state of mind clause in the voluntary intoxication statute refers to crimes which have a particular motive or reason why something happens. And in Ludlow, this court indicated that premeditation would satisfy for that purpose. So we basically have voluntary intoxication being available in crimes where there is a specific intent element or where premeditation is one of the elements. My argument, of course, is that state of mind encompasses more than a person's motives or reasons for acting. And in these crimes...
How is that altered by our McLean case?
Well, I'm not quite sure how to answer that, but I don't really think it is altered.
McLean said that premeditation is not a culpable mental state, and so mental defect or disease doesn't apply to that. So if mental defect or disease doesn't apply to that, why would voluntary intoxication apply?
I guess I would argue 2 points. One, the statute on voluntary intoxication has these 2 phrases separated by the word or. It's a particular or specific intent or state of mind. The legislature would not have included the words state of mind if it meant the same thing as specific intent. So it must mean something different. And I understand that a specific intent is where there is an intent to have a particular result happen. What I'm saying is that these crimes of interference and criminal trespass have within their terms an element which requires a specific knowledge on the part of the defendant.
I think there's a distinction between the 2 statutes, the 2 crimes that you're talking about. One is knowingly interferes, which is worded like it means the culpable state of mind under the statute. Whereas the other one is enters or remains with knowledge, or who knows that the...
To the extent that is a difference, I don't see it as a significant difference in these cases, because these crimes, for the crime of interference, it requires that the defendant know or should have known that the person being obstructed is a law enforcement officer. The crime of trespass requires that the defendant know that he's not supposed to be on a premises that's at issue. These are elements that require a particular quantum of knowledge. They acquire awareness of a particular fact, not just a general knowing act or a general intentional act or general reckless act. It's knowledge of a particular fact, and that makes them much more like a specific intent crime.
And my problem with that, I keep, as I've wrestled with this, I keep looking at 215202I, which is the knowing and knowingly stuff. It talks about knowing the circumstances, that certain circumstances exist. And so why, and then it says that's a general intent crime. So if knowing that the circumstances exist, and then you look at the criminal trespass statute, which says a person who knows that that person's not authorized or privileged, to be there, why isn't that just part of the circumstances? And therefore, by statute, a general intent crime.
Because I don't think that element would be in there if that's what was encompassed in just a general knowingness, knowingly committing an act. These crimes are different because they just don't say that the act must be done knowingly. They require evidence of, and that's the language of the statute here. The voluntary intoxication require state of mind is a necessary element for a particular crime. In these crimes, knowing that someone is a police officer or a law enforcement officer, or knowing that they are not to be on a particular property, is a particular element of the crime.
But I'm struggling with the same thing that Justice Biles is, and I'm not finding your answer to really satisfy my concern that, yes, you have to know all of the elements to have committed the crime, and that is an element of the crime. But it's still just, it's a circumstance of committing the crime knowingly.
I guess I don't see it as that way, because if that was all that was necessary, is to prove knowing conduct.
Knowing conduct in a particular circumstance.
Then you wouldn't have to have an element that you specifically know that you're not supposed to be on a particular premises, or you wouldn't have to have a separate element saying that the defendant knows that the person obstructed is a law enforcement officer. If it was just a general intent, I'm not sure how to phrase this any longer, because in 2011, of course, the legislature revamped the Kansas Criminal Code, and so now almost all crimes require proof of a culpable state of mind. Well, this statute talks about state of mind. I guess I'm kind of viewing knowing, intentional, and reckless as the equivalent of general intent. But when a statute says they have to know a particular fact, they have to be aware of a particular quantum of knowledge, that is more on the level of a specific intent, because it's a separate element that has to be proved, not just knowing conduct.
Would you then say that most of the crimes that have any kind of culpable state of mind then would voluntary intoxication would qualify as an instruction?
Well, I guess as much as I'd like to, I don't think that that's probably a reasonable interpretation, because my interpretation of what the legislature did in 2011 is that they created these three types of culpable state of mind. Now, the terminology they used in creating them, state of mind, would seem to mesh well with 215205B, but, my understanding is that's more of a general intent, knowing or intentionally, knowingly, and recklessly. What I'm saying is these crimes at issue here require something more than that. They don't require proof of just knowing conduct. They require proof of knowledge of a particular fact, which is similar to requiring proof of intent to permanently deprive. It's not just that you acted intentionally when you committed a theft, it's that you had the intent to permanently deprive a person. And in this case, it's not just that you were on somebody's property intentionally or knowingly, it's that you knew you shouldn't be there. There's an extra quantum of proof in one of the elements that goes beyond just the general intent or the general culpable state of mind. I'm not
I
sure.
do have a couple of quick record questions that
Sure.
bear on harmlessness, even if you win on error, or clear error in this case. First of all, there was some evidence that was mentioned in at least one of the briefs that he did a lot of extra drinking at some point in the evening. That was after the argument with his wife at his own residence, but before he showed up at his mother's residence the first time, right?
That's correct.
Okay, which is why I think you argue that there's a difference in
Right.
the evidence of how intoxicated he was during the drug crime, where he took possession of the marijuana and the paraphernalia, and the time when he would have committed these other two offenses.
That's correct.
Okay, wanted to make sure I was clear on when that happened. And then the other thing that's mentioned in the briefs is that at some point he called the officer by name,
Yes.
and you agree the record reflects that?
Yes.
At what
least
point in time did that happen?
that would have been after that considerable amount of drinking.
Okay, but during the first encounter with the officer when he was told not to return, or during the second encounter
Yes,
with
during
the
the
officer?
first encounter.
Okay, thank you.
Sure. One other point I would like to make. In the state's supplemental brief, it talked about the Kershaw case and how in that case this court found that aggravated assault on a law enforcement officer, this court found that that crime is not subject to voluntary intoxication, and the state in its supplemental brief said that was because that crime required proof that the defendant knew that the person assaulted was a law enforcement officer. But that's not correct. That crime does not require proof that the defendant know that the person assaulted is a law enforcement officer. It merely requires that the officer be in uniform or be identifiable. That's a different thing than having a quantum of knowledge and proving a quantum of knowledge in the defendant's mind. It's just that element refers to how the officer is identified, not to whether the defendant knows that he's a law enforcement
And
officer.
that was what I was trying to get to before when I asked you about differentiating between the two crimes you're discussing here. Because I don't see a difference in this statute on the interference. The way I read it, when you remove the language that's irrelevant to the dispute today, is the knowingly only modifies the obstructing, resisting, or opposing. It doesn't talk about, which can mean knowingly in the conventional sense of a general intent crime, you engage in knowing conduct. Knowingly obstructing, resisting, or opposing any person authorized by law to serve process. It's just a person. It doesn't say whom you know to be authorized. It's different from the wording of the criminal trespass, which says entering or remaining upon land by a person who knows such person is not authorized. They are different. I think if you're trying to say there's something additional going on these two crimes, those two crimes are different from one another.
Well, I recognize the importance of how the statute reads. I would urge the court to look at how the instructions read that are given to the jury, because I think what they're being asked to find does indicate that they're actually being asked to find some extra, as an element, which is what makes it applicable to 5205. As an element, they're being asked to find some extra quantum of proof, some knowledge of a particular fact beyond general criminal intent, and my time has expired, so unless the court has any questions.
Do we have any further questions? Thank you, counsel.
May it please the court, Richard James, Clay County Attorney, on brief for the appellate, the state of Kansas. I follow the appellate defender's argument here. However, I believe I've taken it one step further, and perhaps this goes to the question Justice Rosen asked earlier, and that is, if you decide here that indeed the defendant is entitled to that instruction because there was something else required for him to know, I think it kind of gets to the whole legislative scheme here. The legislature has given us in 2011 these three different culpable mental states, if you will. And in essence, if we decide that because of that conjunction or in there, that the voluntary intoxication instruction is going to be available, I'm not sure how we now, at least as to voluntary intoxication, I'm not sure how that means anything
And
anymore.
so we would be left with the situation that a person couldn't be criminally punished for a lack of mens rea?
Essentially, involuntary intoxication cases. I think that
And theoretically, why is that bad? If you're incapable of having the requisite criminal intent, then why is it bad that you don't get convicted for that?
perhaps in theory, it's not bad, but that's not what the legislature told us.
Well, what does the phrase "other state of mind" mean then?
Well, I think that's at debate here. Mr.
Well,
Cattell,
which position are you advancing to us? What does that
well,
mean?
Mr. Cattell says there's probably two possibilities here. In other words, other state of mind has always been read to mean the same thing as specific intent. Or, I believe he says, if I understand his brief correctly, this other state of mind has never really been defined, but it's something other than option number one.
He's just arguing it's never come up in a previous case, that the specific intent rulings from the past, on which we've relied recently in Kershaw, arose out of cases where it never came up, that it was about the initial phrase before the or, not the phrase after, right?
Right. I would agree, Justice. I would agree. And so I don't know that it's ever been clearly defined. And Justice Stiegel asked me today to define that. And I don't know that I can. When as a county...
Just the first blush, ordinary reading of that phrase is very broad.
Yes, I would agree.
It would be hard for you to dispute that, but...
Yes. And I think...
Well, let me just cut to the chase.
Okay.
How do you prevail in this case? If other state of mind is a broad statement that actually has some meaning in the statute.
I think the state prevails here by encouraging this court, as I'm sure it always does, to look at the broader statutory scheme. In other words, if Mr. Cattell's interpretation is correct, if I understand his argument correctly, then essentially the voluntary intoxication defense would be available for all crimes except for strict liability crimes. That would be my logical progression here.
Are you making an absurd result argument?
I think
that we can't construe this according to its plain meaning because the result would be absurd?
I think it would bring us to an absurd result in that that's contrary to the statutory scheme the legislature has given us that says...
How do we know it's contrary?
Because they've given us these three states of mind, I guess.
But I guess I don't see how that naturally leads to the conclusion that the legislature didn't want voluntary intoxication to be a defense for, quote, other states of mind.
And if we would adopt Mr. Cattell's reasoning, I think he would argue that that's exactly what the legislature is arguing by putting in the conjunction or and giving us specific intent or any other culpable state of mind. I think if that's the reading, then we would have to assume the legislature intended for the voluntary intoxication defense to be used in any crime that's not strict liability. I think that would be the logical follow-on assumption. But once again, I just have a hard time when I read the whole statutory scheme thinking that the legislature intended.
That's basically the absurd results doctrine, which
Exactly.
is we don't necessarily see anything definitive in the statutory scheme, but we just think
Construe it.
it can't possibly be this.
Right, and that would be my argument. I think the legislature spent too much time back in 2011 when they redid our culpable mental state statutes. I think they spent too much time clearly defining to us or trying to clearly define to us different states of mind. And I'm not so sure, but I don't know, if at that time they looked at voluntary intoxication defense and said, whoa, if we go here, we are creating this anomaly, this absurd result, whatever you want to call it, where now all of a sudden in Kansas, if you're drunk or intoxicated from something else, then we intend for it to be used for every crime except strict liability.
You
Why
don't
would
have-
there,
excuse me.
sorry, why would we have the word specific intent in 5205B if it also has or other state of mind? Doesn't that latter phrase just take care of it all?
It would, I think, and in fact, I think after 2011, you wouldn't really need this statute at all. Or maybe a very modified statute that says, except for crimes of strict liability, the voluntary intoxication defense is available, and then it would simplify all our lives in some ways, and that we wouldn't be having this argument, and at the trial court level, we wouldn't be arguing all the time about whether or not a crime was a specific intent crime or a general intent crime or a reckless crime.
Do those two phrases lead us to ambiguity on what the legislature is trying to tell us?
I do believe it injects some ambiguity into this argument. And in fact, until Mr. Cattell made this argument in the brief before the Court of Appeals, it had never dawned on me to read the statute that way. But as soon as he made the argument, that was my first thought, is I thought it's very ambiguous. So then I defaulted to, in my mind, as the lowly Clay County attorney, what's the Kansas statutory scheme trying to tell us here?
We can do more than that if there's an ambiguity, can't we? We can look at legislative history.
Yes, we can.
Do you have any legislative history
do
to
not.
present?
I do not, Justice.
As far as you know, is the legislative historical record silent on what was intended for voluntary intoxication post amendment to culpable mental states?
I do not. I do
Okay.
not know.
And it doesn't say culpable mental state, does it?
Right. No, it
It
doesn't.
doesn't match it.
Right. And that was a word I inserted, but that's not in the statute.
Justice
Would
Breyer, was that
you-
your question that I
That was
kind
my
of cut you
question.
off? All
Yeah,
right,
thank you.
thanks.
If you combine the effect of the Ludlow case and the McLean case, does this other state of mind have new meaning, perhaps, that it didn't have before the culpable mental state? Because Ludlow tells us that the intoxication defense is available for premeditation, and we have always talked about premeditation as a state of mind.
Right. And that Ludlow almost makes me think there's a fourth state in there, somewhere between general intent and just simple intentional, between the intentional state of mind and general intent crimes. Is there a fourth one now that we need to talk about post Ludlow? We say, okay, this is a general intent crime, but because there's certain elements that require something beyond general intent, but we're not to the level of specific intent, have we created a fourth state post Ludlow? That's one of the things I thought about when I was writing the brief for the Court of Appeals. I wondered.
Do you have
And
it?
I'm not sure that is intended by the legislature.
And you're saying create a fourth culpable mental state?
I'm saying that Ludlow reads as though perhaps this court, whether intentionally or unintentionally, almost set up a fourth mental state, something that was beyond general intent but not quite specific intent, if you follow my meaning, because obviously in Ludlow, this court held that rape required more than just general intent because of the knowledge of the state of the victim, as I understand Ludlow.
Ludlow was a pre-med case. Anyway, you can check.
Okay. And so I don't know whether this court intended to set up a different category or not, but as a practitioner out there, it reads almost as though it did.
This is clearly erroneous.
I don't believe so.
No, I mean, the
Standard.
standard is clearly erroneous
yes.
because it wasn't requested.
Right.
And under clearly erroneous, we must be firmly convinced that giving the instruction would have made a difference.
In the verdict.
And so I'm assuming your argument is that they gave the instruction with regard to the drugs, it didn't make a difference with the jury, and so that's why we can be sure that it didn't make any difference, or we don't have to be sure, but that's why it wouldn't make a difference. But you have a different argument over and above that one as to why it would not be clearly erroneous.
I do have that same argument. I would just tag on to what Mr. Cattell said, and that is they rejected the argument as to the drugs, but that was before the additional drinking. And so I don't know that I would have an additional argument other than that the jury clearly understood that there were two different incidents here, the drugs possessed earlier. But I would also argue that the facts of the case would indicate that Mr. Murren certainly knew who the officer was. He called Officer Galindo by his first name. He ran from the officer. One of the things that came out at trial is when he jumped over when Officer Galindo ordered him to stop. This was after the drinking bout. He jumped over the railing on the front porch and ran from the officer. And the officer was specifically asked on direct, did he stumble? Did he have difficulty running? No, he jumped over the railing on the porch, landed on both feet, and took off running. And so I think that and this was all post-drinking.
That's about impairment.
Pardon?
That's about how impaired he was, right?
Right. And so I think, and again, I'm speculating, but it seems to me like the jury hearing that testimony is thinking, this guy is not particularly impaired. He may have been drinking, but he is not so impaired that he doesn't know Galindo's name, the officer's name, and that he can't jump over a porch railing, land 3 feet lower on the ground, hit with both feet and run.
The defendant's explanation was that that everyone admits that there was evidence that he knew the officer's name on the first encounter with the officer. On the second encounter, defendant's story is, I thought it was the guy who beat me up earlier came back, right?
Right. But in his first encounter with the officer and the second encounter with the officer, only about 15 minutes apart.
Yeah, right.
So...
and there isn't any evidence of additional drinking?
No. In fact, it
abuse.
appeared, Officer Galindo testified he watched the defendant walk down the street. He sat there about 10 minutes and watched the defendant walk back up the street. So I think if I were guessing, I would say all of those were probably taken into consideration by the jury in deciding whether or not he was truly so impaired he didn't know what he was doing. And so that goes back to Justice Johnson's question about the clearly erroneous standard, and that is it would be hard for me as a prosecutor to imagine that the jury would have come to any different conclusion, even had that instruction been given on all 4 counts.
Do you have any further presentation?
I have nothing further.
Any more questions? Thank you, counsel.
Thank you.
The statute reads, particular intent or other state of mind. My understanding historically is how that has been interpreted is particular intent refers to specific intent offenses because the word intent is used. And previously and still, as I understand it, involuntary intoxication is available for specific intent offenses when there's evidence to support it. Other state of mind, well, particular intent is one state of mind, but there are apparently other states of mind that the legislature was contemplating, which could be valid, make statutes applicable to voluntary intoxication.
To read that language, to give it its natural and plain meaning, I guess, if you will, why isn't the state correct that would, in effect, mean voluntary intoxication is a defense to all crimes, with the exception perhaps of strict liability crimes?
The way I'm viewing is that intentional conduct, knowing conduct, reckless conduct since 2011 are more general intent.
Sure, but they're states of mind, aren't they?
They are, but I'm not making that point because what I'm saying is in these crimes, the ones that issue before the court, there is an element.
I understand I do understand your argument, and it's nuanced, and it makes sense. What I'm trying to figure out is what does the statute mean, and I understand that's not
Remember
really
this day.
that's not really your driving motivation to help us understand what the statute means necessarily.
Let me try to explain it this way. I'm viewing there are two types of crime. There are specific intent offenses, which clearly voluntary intoxication can be given. These two crimes are specific knowledge offenses. And state of mind must mean more than a person's intent. It can also encompass...
I guess I could rephrase my question. If we accept your argument, why would we stop there? What in the statute would cause us to stop where you're drawing
What would
the
stop
line?
you is that because in the grand scope of, all but a handful of crimes require proof of some culpable state of mind under 2011. But not all of those statutes are like these that have an element requiring a particular quantum of knowledge of a specific fact.
So do you think it would also be an absurd result to construe this language to mean any other state of mind?
Well, I don't think that's probably what the legislature had in mind. I'm not going to go so far as to say it's absurd, but I don't think that's probably what the legislature contemplated would be the result. But I think in this case, these crimes should have available as a defense voluntary intoxication because they have a particular element that goes beyond just general knowing conduct.
Well, if you're not going to agree with Justice Stegall, it would lead to an absurd result. Let's go back to another issue that was raised with opposing counsel, and that is, why have those two phrases? Why not just go with other state of mind and call it good? Because that covers specific intent crimes, does it not?
Well, that language seems to include intent within the scope of whatever state of mind means.
So why was the legislature putting in that specific language, specific intent?
I don't know the answer to that. I can only speculate that when they were doing that, they were thinking of specific intent crimes. But they weren't limiting the application of voluntary intoxication to only specific intent crimes because they included this other clause of other state of mind.
I guess I didn't understand your argument then, because you said particular intent were specific intent. State of mind wasn't all general intent, but only a subset of general intent, which would be a reason to have those two phrases, the particular intent to be all specific intent, state of mind to be the subset of general intent crimes.
Well, I think
I thought that was your argument, that you're arguing these are subsets of general intent that require a specific knowledge, and so they fit into state of mind. Isn't that your argument?
that is my argument.
And you're saying not all general intent crimes are encompassed by that phrase.
What I'm saying is that setting aside specific intent crimes, we know those are subject to voluntary intoxication, but where the elements include a specific element that the defendant have a particular piece of knowledge in his mind, that is something more than just knowing conduct.
So that would be a subset of a general intent crime, those that require a specific knowledge.
It would be
Let me just clarify. Your argument today is not that or other state of mind encompasses all general intent crimes.
That's true.
Okay. So you're arguing there's a subset of general intent crimes that was meant to be encompassed by the phrase other state of mind.
Can I try to explain rather than just answering that question? In 2011, the legislature created these three types of conduct. I'm viewing all of those as just the general intent that needs to be proved for the vast majority of crimes. But when the crime either requires a specific intent or whether it requires a specific piece of knowledge, then that makes the crime applicable to the defense of voluntary intoxication.
And how is, I'm hearkening back to jury trial instructions, and you're going through this, how is it that the court and counsel argue whether, if we adopt your point of view, whether or not voluntary intoxication fits into one of these subcategories? It's going to be, I don't know how to make it a clean analysis at all.
Well,
How does that work?
I mean, I suppose it would work just like it works for specific intent. If one looks at the elements of the crime, what the jury has to find and says that you have to prove an intent to permanently
Usually that's
deprive-
fairly clear because it says with the intent to. There's some language. Now we're getting off into a territory that's going to be pretty confusing and complicated, aren't we?
I don't think so, because I don't think there are that many crimes that are like this that requires a specific element that the defendant have a knowledge of a particular fact.
Do we have any further questions? That concludes your presentation.
Thank you.
Thank you, counsel. Thank both of you for your arguments this morning. Court will take this matter under advisement.